Start recording and start us going here in class. Tonight we're going to cover American planning law. Nancy should be here hopefully. I think traffic may have caught her a little bit, but I'm going to take the time to address some of the past test taker comments. And if you've got a question, unmute yourself and ask me a question. So here are some from the fall, and I'll give you more than just the fall, but more questions than I expected, including some cases I'd not seen. Another person was adequately prepared for most of the questions. Another one had Berman, Hadachak, Lucas, Dolan, Nolan all tested. The rational nexus was tested multiple times. Somebody had a few obscure law cases that I didn't know were tested. One was Livermore, which is a routine one we teach about, which I saw in study materials but couldn't remember. Another one said tested theory on nuisance torts that went beyond what I studied. Most of the law cases were straightforward and on major cases. I had one that was a quote from a case that was a bit more difficult than the others. I had one question that was a pick which historical law case question. It was a which growth management case, except there was a specific word for word quote. They felt a little bit like Trivial Pursuit question. I experienced questions that would detail a situation and say which of the following would be in accordance with X, with either that person or that law case. All right. Another one said this was surprisingly my easiest area. I know the law cases in and out for the most part. All that showed up on my exam I was proficient in. Another one had the type of law practiced prior to zoning, Mugler versus Kansas, Hadachak versus Sebastian, Pennsylvania Cole versus Mann, Euclid, Berman versus Parker. These are all ones that come up routinely. Surprisingly few law cases. Again, one person may get a few, another person may get many. Sometimes they want the application of the principles. The ones I got were easy for the most part, like Berman versus Ambler, or the really old one that outlawed the liquor sales. There was a quote I was not sure about, what was involved in growing at your own pace. Two questions about home rule and Dillon's rule. These are all things we'll touch on tonight if you don't know what they are. Another person watched different videos they found helpful. That second video, the YouTube one, I think is an older version of our presentation that somebody took from the FTP site and put it on the web. I think you'll hear Nancy probably, who should be here tonight if she's not caught up in traffic. I think law and history is most helpful. I felt adequately prepared. Okay, from the steps listed, which comes first in the process of a bill? This is something that comes up all the time on exam, and which is why I'm going to specifically try to address it. In the past, often we put things on the FTP site that cover where we may get one question like that. So you have to look through stuff, but people seem to miss that, so I'm going to just touch on it tonight if we get time. A new bill was introduced. What would be the first step? There was one question that presented a situation where a bill is introduced to a state Congress, legislature, and a question about that was what is the first steps that happen after the bill is introduced? I guess on my understanding, I had a bill about the first step in a bill passing the legislature. Asked when a bill comes to the legislature, where does it go next? I know it goes to committee, but two of the answers were quite similar, but both had a committee aspect to them. So we'd have to know what they're saying different. Because usually it goes from one committee maybe to another committee, or if it's in one committee and there's some questions about it, it may go to a subcommittee of that committee. But basically it does that, and then eventually it gets voted on by one house, and then it goes over to the other house. That's the typical way. Sometimes they can be submitted in both houses simultaneously, a House and a Senate. But we'll talk about that, and we'll give you some graphics that just make it a little easier. Some of the same cases here, including Petaluma, which Petaluma and Livermore are two that you need to be able to distinguish between. Could have more on case law in the background, more detail on established tests, rough proportionality. So this person wants us to expand what we do and take a whole night to do a little bit. Most are straightforward. Other two that you need to know the backgrounds, information, details pertaining to the outcome, difference between Livermore and Petaluma. They're typically lumped together. Some of the same things. Some of the same cases here. Adequately prepared for law. They gave me a quote and asked which that was related to. I didn't know the answer to that. Dillon's rule versus home rule, law cases. Many of the law cases were straightforward after memorize them, but I had a question where both Nolan and Dolan were options. I have to know the difference between what Nolan does and what Dolan does. And often they may ask you a question, if you got a bike path, which one of these two would you deal with? Well, one of them dealt with bike paths in a way, and the other one didn't. The other one dealt with more coastal view and access and things like that. So, look first to see if it fits the scenario. If it does, then that's probably the answer. That's probably where they're trying to get you to go to. If it's about a trail or about a bike pass and exactions for it, is probably talking about Dolan. We'll talk about Nolan Dolan, and they're part of a two-part test that go together.
Nolan's rational.
Sorry?
Nolan is rational nexus.
That's where the term essential nexus came from by the Supreme Court, which is very similar to rational nexus, which is a term used by the states primarily. Like in Florida, we use rational nexus, but essential nexus and rational nexus, they're often the same thing, although you can consider that rational nexus may be both parts of the test, Nolan and Dolan. But we'll talk about that a little bit. Had trouble with Dillon's rule versus home rule. Also, home rule and Dillon's rule did came up, but the home rule was different than expected. You had to pick one. And then there's other comments from other years, other tests. Okay? So that's some of the feedback that we had. And I'll put this into a PDF and give it to you along with other things. Now, rather than starting this without Nancy here, I'm going to try to start the legislative steps first, and then we'll come back to this when she gets here. If she gets here, we'll switch right over. Okay, so as you saw from the commentary, there have been questions about what happens, how does a bill, what happens when a bill gets introduced in Congress or in the legislature. I'm going to take the federal process first. You can blow this up on your own and take a look at more detail. But there's many ways that the bill can get proposed or into a congressman, okay, and whether it's a representative or a senator. But anyway, once a bill comes in, it gets introduced as legislation, all right, and then it's going to get assigned to a committee. That's basically the first step. Now, in the House and the Senate, there's slightly different things. There's something called a hopper, things like this. Don't get confused by that. I think what they're looking for is probably this first step, which is the bill comes in and it gets assigned to a committee to start working on. Then it starts getting through committee work. It may go through a subcommittee of that committee. It may go through multiple committees. And then eventually it gets up to where it's debated by the whole House or the Senate. And they work on that. And if it gets passed through one of the houses, it goes over to the other house. That's the typical way. Sometimes it can be simultaneously proposed in both houses at the same time. As long as both versions are identical to them, if they get passed by both the House and the Senate, then they can go to the president. And there's different types of veto ways and pocket vetoes. Don't get hung up on that. Again, I think they're looking for this guy. All right. So anyway, this is the whole process. It's pretty straightforward. If it goes through one house and hasn't, like it's gone through the House and hadn't gone through the Senate, then it gets sent over to the Senate. If it gets approved identical to the House, then it goes to the president. If it gets changed, then the House and the Senate have to get together in a conference committee and work out any differences and come up with a consensus bill that goes back to both chambers and gets passed both, and then it goes to the president. And just as you've seen in the current one, things can happen. A bill can be passed in the House, go over to the Senate, and the majority leader just decides he's not going to bring it up. And it just sort of dies there then. Okay? Doesn't get a chance to even get voted on. That happens a lot in the type of situation we have right now. So now, that was the federal. I'm going to give you Florida's example of how the legislature works, and it's very similar. All right? It's very similar to how to think. Somebody approaches a senator, they draft it, they take it, they have a first reading, it gets introduced to the legislature, and then it's going to go to committee hearings. Okay? And the committee can do different things with it. Once, if it gets through all the different committees, including the rules committee, then it goes and gets heard by that chamber and gets voted on. If it gets passed on one voter, then it can go over to the other, other house and do it the same way. And it's very similar if they disagree or change it, then it has to come back for a conference committee and work it out, work out the differences. And then eventually goes to, the governor, and which he can do certain things with it. Each state is a little bit different on how their state legislative process works, but this is a general idea on how they do it. Again, I think what they're asking for is mostly this, knowing that the chamber that it's submitted in, it goes to that same process, and as long as it gets approved in the one chamber, it can go over to the other chamber. Once it's approved identically, then it can go to the governor. That's the general process. All right, that's all I'm going to spend the time on it. This is just you can take a look and see how it works, or you can look up a little bit more. They used to have a kids program that always talked about, Capitol Hill and how a bill goes through and things like that. Go look at that if you want. All right. Since we've only got, I don't know, was traffic bad when you came in?
Oh, yeah.
Parking?
It took me an hour and 45 minutes to come.
Okay. So we may have a traffic or a parking problem.
Both.
You had parking problem?
Yeah.
Okay. So I'm going to go ahead and start a little bit with Nancy's presentation, and then I'll give it over to her once she shows up here. All right. Because I have not gotten a call from her yet. So, all right. This presentation we originally developed for the 3.0. Well, we developed it here for class, but we turned it into a type of presentation that could be used for the APA 3.0 study guide, which they just phased out. All right. And it's been modified different times as we get feedback. Frank Palin did the original program. Nancy's modified it sometimes. I modified it a little bit to add some new stuff to it. And I've given it, Nancy's given it, Frank's given it. They do a better job. They're both attorneys and AICP planners, but I will take it, my best shot at it. So basically we're going to try to cover 5 sections here. What's the foundation, the basic framework for planning law in the U.S.? How do the Constitution and land use regulations come into play? What are the federal power and the nature and limits of those power? We're going to talk about the 5th and 14th Amendments taking, talk about the 5th and 14th Amendments due process, talk about the 14th Amendment, equal protection discrimination, and talk about the 1st and 14th Amendments, speech and religion. For the most part, and I will give you a handout with underline in it as other related materials here from Frank Palin. You have to know the 1st Amendment, the 5th Amendment, the 10th Amendment, and the 14th. Okay? So the 1st, the 5th, the 10th, and the 14th. Those are the main 4 amendments that they tended to ask you questions on. Then section 3 is going to be about zoning and growth management law. Section 4 will be about standing. And then section 5 is, can you rely on the law? And here is Nancy. I just barely started, Nancy, so we'll take a second. Get Nancy sit. Go ahead and sit here and I'll move the mic over for you.
All right.
Okay?
Hi, everyone.
Nothing like hitting you right. They've been having trouble with both traffic and parking, so we figured that was part of what was going on.
Yeah, no, I had to
So-
park behind the pool.
Yeah, so I went ahead and I did the how a bill becomes law.
Okay, great.
Okay. And I went over the past Bittaker comments. Okay.
Okay.
And so I just barely started your presentation because I wasn't sure, but I figured it was a parking
All right.
traffic issue. So we're just finishing the outline. I don't know if there's anything else you want to.
I actually had a
You have a
updated
new
one. But I think we're okay. I can just add in
Okay.
what we need.
So we just did the outline. And, so I'll hand it over to you.
Okay.
Make sure that everybody can hear you and see what's going on.
Well, first of all, good for you for taking the class and the test.
And we have about 30 online.
Oh, hi, everybody. Good for everybody out there.
We will have some that they come from a little longer way.
Yeah.
So in class, they'll show up, but I know you said you had like an hour and a half.
I was hour 45 coming out.
Hour and
Oh, my
45 minutes
gosh.
coming in.
I'm near the stadium, near the Super Bowl stadium.
Oh,
But still,
yeah, no, that's commitment. And I will assure you that this is, Henry and Susan give you the best resources and the best preparation. So
And I'll let
you can
introduce yourself
have
a
some
little
good
bit.
confidence that things are going to be okay. I'm Nancy Stroud. I'm a land use lawyer, FAICP, and I'm happy to be here. This is probably my 12th time, maybe 20th time doing this. And I rely quite a bit on the original PowerPoint that Frank Palin put together years
We
ago.
talked about this.
And okay, that both Henry and I have massaged over the years. So here we go. Let's talk about the foundations of land use law and sort of give you a basic framework for thinking about the cases and the study materials that you'll need to be familiar with.
And unfortunately, if you hear a little disturbance, it's food just came in.
Okay, a lot of what planning and zoning law is about is the use and regulation of private property. So this slide talks a bit about what private property is. Private property is described in a metaphor called the bundle of sticks, which means that there are lots of different parts to property that together make up the bundle of real property rights. And here we're just talking about real property, land, in other words. And certain aspects of real property include, for example, what we typically think of as real property, that is the surface of the land, where we build our homes and we landscape and we build all sorts of other things. But also, another stick in that bundle includes rights to underneath the surface, the subsurface, and good example of that is mineral or mining rights, and you'll see some cases about what happens when you deal with those rights, like rights in coal mining. And then above the surface, which includes the air rights, and a lot of modern construction deals a lot with air rights because we build a lot taller now than we used to. And then, of course, there's rights to different aspects of land, including water. If you're a landowner, you have certain rights. If you're adjacent to water, riparian rights and littoral rights, and rights to underground water. And those rights change according to what state you're in, what time you're in, but that's another aspect. And then there are different rights of use and enjoyment of the property, of all this basic component of what land and above land and under land is. You have different ways to use the property and enjoy them. So you have the right to use and enjoyment. You have certain rights to what the law calls alienate land, which is, sell, lease, devise, meaning pass down to your heirs. You have rights to exclude others in American jurisprudence, and that's a very important right when it gets to constitutional takings claims. And you have a right to derive profits and produce from the land. That doesn't mean these rights are unlimited, and really what private property law is about is how limited, how restricted or unrestricted those various aspects of rights are. This slide shows a map of main legal systems, which sort of gives you a basic background. The legal systems in use in the United States are civil and common law legal systems. Civil law being what is enacted in statutes and legislation, and common law being that kind of law that's been passed down to us through case law. We'll go to the next slide. All right, so it's important, and this is a good test question, to realize that our American system of private land use regulation really is based basically on nuisance law. That's the original law that forms the basis of American land use jurisprudence. So nuisance in American law is a common law principle. It's an old English, common law principle handed down through case law. Now also it can be governed by statutory law, and it's what's called a tort, which is a great legal term for what is a civil injury. So anybody who likes Scrabble, tort is a really nice word that unless you study law, you might not really realize what it means. So the general rule of nuisance is that old adage that my home is my castle. I have a right to quiet enjoyment of it. In other words, you have a right against nuisances to your property. There are two different kinds of nuisances. One is private nuisance, and that's what it's normally thought of as, the tort of nuisance. It probably covers 90% of all nuisance actions. And that a private nuisance is when your neighbor's conduct interferes with the quiet enjoyment of your land. In other words, your neighbor's impacts extend past his property boundary onto your property in any kind of form that have adverse impacts, such as pollution, smells, sounds, vibration, other kinds of indecent conduct. Your remedy in tort law for a private nuisance is money damages. You have the ability to say you have reduced the value of the enjoyment of my land, and you have to pay me for that value. The other kind of nuisance is a public nuisance, and this is where a person's unreasonable conduct interferes with the public's right to health, safety, peace, and so forth. And the remedy in that instance is the person who's generating the nuisance has to stop, because the public interest can't be remedied by simply paying the public. You have to stop the nuisance. So where does this come in? Well, in one of the earliest cases in zoning law, Hadachek v. Sebastian, which is more than 100 years old now. We started teaching this when it was less than 100 years old. Now it's 100 years old. And that was an early zoning case out of Los Angeles, which had established zoning districts, including one big residential zone. And those new zoning districts covered basically a non-conforming industrial use, a brickyard, and basically said you can't have a brickyard here, because having a brickyard is not what we want in this residential area. And the brickyard owner sued and said, well, this is irrational, unreasonable, and if we can't have a a brickyard here, then you have to pay us for the devaluation of our property here. And in this case, the Supreme eventually got to the Supreme Court and said, no, a brickyard in this instance is a nuisance, a public nuisance. And there's no compensation due you for the abatement of a public nuisance. You cannot maintain your brickyard. So this is sometimes surprising to people to think that long ago, the Supreme Court might have said pre-existing industrial uses, too bad, if you're zoned in a district that doesn't allow that, we're not going to require the city to pay you for that. And that is the prime example of zoning's history from the law of nuisance. Okay, so, yes, sir.
Can I ask a question about that, Casey? Was before they divided into 27 pieces, did they change the zoning of that one district? Meaning when
They
they
annexed the land in. So go ahead, Nancy.
Yeah, that's right. They had annexed it in. It had not had zoning before. They
Oh, there was no
annexed it in,
zoning.
and then it was subject to the zoning.
They annexed it into the city and then created the zoning district, and it was basically
Right.
non-conforming.
And remember, at this period of time, there were very few places that had zoning.
Okay.
So it wouldn't be surprising that newly annexed areas just wouldn't even have zoning. Okay, so the other kind of regulation that is very important in terms of foundations for land use regulation is in easements, covenants, and licenses in contract law. Private contracts obviously govern land which is subject to those contracts. It's sort of the twin to the public government regulation of lands. But private contracts and easements and regulations have a problem in that they usually are limited to, certain impacts or to a certain area. They're expensive to enforce. You normally have to enforce them through the court system instead of through a government regulation system. And that kind of enforcement is very slow. It can be very expensive and thus is ineffective. So that traditional way of regulating land use through private covenants over the years has been found to be really insufficient to deal with a lot of the public issues that are dealt with through zoning. So the solution to that limited ability to regulate land use has been to have government regulate, to protect against private nuisances, a neighbor's selfish exercise of their property rights, and planning and zoning are thus born. Okay, so government has a wide variety of ways to plan, to influence the development of communities, all under the public purpose to protect the public health, safety, and welfare. And this is a list. I mean, it's obvious government can create wealth by minting money. Government taxes and spends, that reallocates resources. Government has eminent domain or condemnation power. It can take property. Government has contract powers. And those powers are used to purchase land, to borrow money, to employ planners, to establish regulatory systems, et cetera. Government owns and operates infrastructure and land. Government regulation creates private property, or at least the definitions and boundaries of private property. Regulates interactions with other governments, issues development orders and permits, and has enforcement power. So there's a wide variety of government powers, and zoning, we're really talking about one slice of that extensive system of power. So, and that slice is really the use of zoning through the exercise of government's police power. What is police power? It's not law enforcement and sheriffs and police departments, although that's part of it. Police power is a very general, that's what the courts term, the very general ability of governments to protect the public health, safety, and welfare. And in that regard, the police power, when it is exercised through legislative action, through enactment of laws or regulations in the court system, are presumed to be valid and constitutional. Any private party or any party challenging the exercise of legislative police power has the burden to prove that the exercise of that police power is unreasonable. Unless the Supreme Court or the statutes shift that burden, but generally 99% of the time, the burden is on the challenger. And another old case, the Munn versus Illinois case from not last century, but the century before, was an early example of the Supreme Court allowing states to use their police power very broadly. And in this case, Illinois had passed legislation to regulate railroad hauling rates, and the railroads sued and said that's beyond their police power. And the Supreme Court said no, that the police power is a broad power, and in that instance was not unreasonable. A very early example.
There's some more details.
And there's more detail.
They do ask about this case sometimes on the exam.
Yeah, you can read that. I don't need to read it, but that is somewhat likely to appear on your test. So this is a good one to know. Next slide. Okay, so governments have different kinds of police power, or depending on what government you're talking about, the police power is exercised differently. So, for example, starting with the federal government, under the 10th Amendment to the Constitution, the federal government is limited to powers that are specifically enumerated in the Constitution. So that's a limited power. All other powers are reserved to the states because we're a republic and the states maintain their own kinds of powers. So limited federal government power, how has that played out? Actually, federal regulatory power has nevertheless been broadly implied. So the courts will basically say if it involves commerce, because of the Commerce Clause in the Constitution, we're going to say that it's within the federal powers. But mostly the police power is vested in state governments, and it's considered inherent in the state sovereignty. And in that sense, it does not need to be expressly stated in state constitutions. And in fact, states have power over local government so that state may preempt local government. They have the ultimate legislative power. And we see that in Florida and other states recently. There's been a big push really nationwide to limit powers of local government for certain kinds of actions that, frankly, lobbyists have figured out. They can get the state to say what the regulation of a certain thing can be. Today in the Florida legislature, for example, it's the banning of sunscreen that the state the legislature is now considering that they need to have a statewide regulation so that local governments cannot ban sunscreen. Let's talk about local government power. This is an issue that can come up on your test. The powers of local governments depends on what kind of state you're in. And there are two basic kinds of states. One is where Dillon's rule applies. Dillon's rule is actually out of Virginia, but it describes a situation where the state holds on very tightly to its powers, and unless it expressly delegates to local governments a certain regulation, then local governments are considered not to have that. Florida used to be that way years ago, and so you can sometimes see old local legislation, the original zoning acts in many local jurisdictions in Florida originated out of some special state legislation for them. But since the 60s, Florida's been considered a home rule state, and that's the opposite of Dillon, meaning that if a municipal government is presumed to have power, the police power, unless it's expressly or impliedly restricted by the state, preempted to the state. Okay, and then another kind of local government that is important to think about. We think of cities and counties as, local governments, and they are because they're general purpose local governments, and they're the predominant ones in terms of having broad powers. But there are lots of special districts and public authorities within the state. If you're not a city or a county, you're generally a special district, and those do not have home rule powers. Those special districts are like the old municipalities that they only have the certain powers that they're granted by the state. The last place where the police power resides is in the people, the population, through the power of initiative and referendum. If the state constitution has given the population that power, and that is the power to enact by the ballot through a process that's either an initiative or referendum process, general legislation, or to veto legislation that local government or the state might have enacted. So that's kind of the breakdown of the places where the police power is found. Okay, in speaking about police power, it's become obvious that in our system of government, we have a federalist system, meaning that we share power between national and state governments, as I described. That's not true in all places in the world, obviously, but it is true in the United States. The next one.
For example, United Kingdom, if you want a land use change, you basically have to get Britain to approve it in most cases, all right? So everything goes to the top. That's what a unitary system sort of is. And before we go on to this next section, I'm going to stop just for a second. I've unmuted many of you. I'm not unmuted all of you that have joined late. If you have an issue and I don't see your hand go up, call Susan Kokenauer at 561-523-0677 and let her know what your question is and she'll try to bring it forward, okay?
Or they can email me.
Or you can email her at Susan Kokenauer, COUGHANOUR @AOL.com as a text message and she'll get it that way, okay? Since we've had problems before, we had the audio go out
Oh,
a couple times ago.
oh dear.
We didn't realize it here.
They can text or email.
So you can text or email,
The text goes to the cell phone number.
whichever, okay. All right, so going on, sorry.
All right, so we're going into another section where we talk about the US Constitution and land use regulation. This is a very rich section for test questions. So we're going to go through the US Constitution and specifically various amendments in the Constitution that come up in land use regulation. So if you see on this slide that we're going to be talking about takings.
Nancy, there was a request that you could explain the, I'm sorry, special/general rule again. She didn't quite understand.
The what
Special
rule?
district,
Special-
Special purpose.
/general rule, I think she.
General purpose
Okay.
versus special purpose. I'll go back.
All right, so
Down at the
right.
bottom, you have general purpose and you have special purpose.
Yeah. There are various kinds of local governments. We think of local governments sometimes as being restricted to cities and counties. Those are considered general purpose local governments. They have very broad powers to do a lot of things. And in home rule states, particularly, they have all powers except, of course, if they're preempted by the state. That is contrasted to special purpose local governments, which are limited governments. An example of that might be a community redevelopment agency, a
Like the
water district, any district that is formed for special purposes, a beach renourishment district.
A lighting district, a fire district.
Yeah, a fighting district. There are hundreds of special districts. Those special districts do not have general powers. They do not have home rule powers. They are specifically limited in their authority to what the legislature has created for them in the statutes or in local special.
Yeah. Now, there is a slight
legislation.
difference between Florida and some other states. In Florida, these are basically overwhelmingly created by legislative action, which limit their powers. In some states, special districts can be done by referendum at the local level, all right? But it still limits their power. It's just a slightly different way they're done in different states.
Okay? So,
You have to speak up real loud,
I
Susan.
know, you might want to talk about community development districts here in Florida that are created with new development
Well,
projects.
she mentioned about CRAs a little bit.
But they're not all CRAs.
no, I mean, there are lots of different, and what Susan is saying is, especially in Florida, the use of community development districts is very prevalent because community development districts can be created, limited purpose districts to build infrastructure in new developments, basically.
Yeah.
So,
Okay. So
whereas CRAs are usually downtown, already established buildings that are being redeveloped. So let's go back to the US Constitution and the various amendments that come into play in the cases we're going to talk about. All right, so the Fifth Amendment to the Federal Constitution has a number of protections for people. One protection is against takings of property. without just compensation. Another protection is the equal protection of the law. In other words, it's an anti-discrimination amendment. And a third protection in the Fifth Amendment is the protection for procedural due process and substantive due process. All those protections are made applicable to the states, so the states also have to enforce these protections through the 14th Amendment. Okay, so the Fifth and the 14th Amendment are joined when we talk about protection against takings or equal protection or due process. There's another important constitutional protection in the First Amendment to the Constitution, which protects free speech, protects freedom of religion, and protects against the establishment of religion. Again, that First Amendment to the Constitution, which is original to the Constitution when the Bill of Rights was adopted, was made applicable after the Civil War by the 14th Amendment. So the states have to protect those First Amendment freedoms as well through the 14th Amendment. So this slide goes over what we just said. The First Amendment protects religion, speech, and the ability to petition the government for redress. The Fifth Amendment, quoted here, contains provisions so that persons cannot be deprived of life, liberty, or property without due process of law, and private property cannot be taken for public use without just compensation. And I had mentioned the 10th Amendment earlier in the preemption slide.
The 10th Amendment, the original 10th Amendment, done when the Constitution was first passed, basically laid out what powers the states, that basically said all powers not reserved otherwise are granted to the states. The Constitution limits what the federal government can do. After the Civil War, the 14th Amendment basically applied, it said all those first 10 amendments also apply to the states, and therefore the creations of them, which are local governments.
So this slide explains what Henry was just saying, that after the Civil War, originally to protect newly emancipated enslaved persons, made applicable all of those first 10 amendments to the states. And so you see the quote here from the 14th Amendment that says, "No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction equal protection of the laws." So that covers those items that the earlier slide covered. And you see after the Civil War, this slide shows other amendments that were enacted after the Civil War, again, to protect newly emancipated persons. So a very predominant issue in land use regulation is takings. So next couple of slides here about takings law. And the first question is, what is a taking? And that's a question that's been answered over the years in various different ways, because the courts have decided that there are different kinds of takings, and depending on what taking we're talking about, there may be different protections around it. So the easy example of a taking is government's physical invasion or condemnation of private property. And that's basically what originally the Fifth Amendment was thinking about, where government comes in, says, okay, this property is no longer yours, it's the government's, you've got to leave or we're going to otherwise restrict you. And the Magna Carta back in, old England, had protected people, freeholders, from that sovereign power by requiring the king to pay those who were displaced by that action. And so that's carried over into the Fifth Amendment, and that's the sort of old idea of what a taking is. It's eminent domain. And the courts identify this now as what they call a per se or categorical taking. And that's specifically relevant to land use law, because this kind of per se or categorical taking really only happens when you're talking about regulatory takings, and what they mean and how we're protected. So in a regulatory taking case, the state is not coming in to physically expropriate the property, but they're regulating the property in a way that interferes or limits the private property owner's rights. And that action, that regulatory taking, is also known as inverse condemnation. It's not the regular, physical condemnation. It's inverse condemnation through government action. And then there's another kind of taking. At one point, the court considered exactions or conditions on permits to be another kind of taking. Conditions that require contributions of property or money, for example. So we can go through a number of cases related to all of these kinds of takings. Okay. So very, very important case. You need to know this case. Pennsylvania Coal versus Mann in 1922 has the classic statement on the limits of government in regulatory takings. And this was a case where a coal company had sold surface rights to a person to build a residence on land, but had reserved the underground, the subsurface rights that we talked about earlier, to mine coal in a private contract. That was very common, back during the big coal mining era. And that contract went back to 1878. But around the 20s, when it became obvious what mining coal does sometimes to the surface, like causing, land to subside, the state in Pennsylvania enacted a statute that prohibited mining of coal if it caused subsidence of a residence. And so based on that statute, Mann, who was a property owner of the surface rights, sued to cancel the covenant made by, by contract with the coal company that owned the subsurface rights. And it made its way up to the Supreme Court. And coal company said, this is not, the statute is unconstitutional. This is an example of a regulation that takes our property, takes our subsurface rights, and it should be proclaimed unconstitutional. And the Supreme Court agreed with that. They said that the property rights were taken by the state by that statute, and described a rule that if regulation goes too far, it will be recognized as a taking for which compensation must be paid. So the Supreme Court said here, we're not going to say the statute's invalid, but if Mann wants to cancel the contract, then damages are due to the coal company. Okay, so the question then becomes, when does a regulation go too far? And a lot of the subsequent cases are about that. Fast forward to 1978 and another Pennsylvania case. Don't get it confused with Pennsylvania Coal. It's Pennsylvania Central Transportation Company versus the City of New York. This case is about the New York City Landmarks Preservation Law that was adopted and applied to protect Grand Central Station. This was this Landmarks Preservation Act, which you probably learn in other parts of your studies and, may be tested on, was a reaction to the demolition of another great station, Penn Station. And the city decided that it would apply historic preservation and enact this Landmarks Preservation Law. And the law protected the existing Grand Central Station from development that would be contrary to historic preservation aspects. It did establish a transfer of development system at the same TDR system, transfer of development rights system at the same time, so that owners whose properties are landmarked could transfer their air rights, above the surface, above the building that they already had, to other sites in the area. And there's more specificity in the landmark law that says just how that would work. But the transportation company was not happy with this landmark preservation law, and they sued and said that this was a regulation that went too far, and it should be considered inverse condemnation and a regulatory taking. So this was the opportunity for the Supreme Court to say what it means for a regulation to go too far such that compensation is due. And the Supreme Court put together a three-part test that is still applied today to determine in case-specific, fact-specific circumstances whether a regulation is a taking. And the court said we really need to look at, one, the entire property, not just a portion of the property. It's the whole parcel rule. In other words, that property is a bundle of sticks, and just because you take out one stick doesn't necessarily mean that you've gone too far, because you have other sticks in the bundle. So the court's always going to look at the whole entire property, not just the air rights, for example, in this case. They're not going to say, okay, you took away all the air rights, so that's a take in, you have to pay for the air rights. They're going to look at all the other rights that the owner has, including the right to transfer development rights. And the three-part test, once you get past the entire property, is the court will look at the owner's reasonable investment-backed expectation of value. What was the owner's investment expectations at the time it purchased the property? It will also look at the nature of the governmental action to see whether it's a per se taking, is it a physical invasion, or is it what the court called a mere regulation of use, and the reasonableness of that use. And then the third test is to what extent the regulation has diminished the value of the property. Three-part test, very important to remember. This is pretty much really basic and may very well come up on your test. The next slide. So in this particular case, the court determined that this was not a regulation that went too far, that the transportation company still had the present use of the terminal, can use the property precisely as it's been used for the past 65 years. And that the court determined, since the transportation company had owned this for many, many years and been using it as for this purpose for many years, that was the reasonable investment back expectation of the company. And also decided that based on the record, there was a reasonable return that could be expected on the investment. So, in summary, the owners could not establish a taking merely because they were denied the right to use their airspace. The landmark law was considered to be a reasonable law, comprehensive plan for historic or aesthetic purpose and not discriminatory. The fact that the law affected some owners of landmark properties, more than others, did not itself result in a taking. Again, that there was no interference with the present use or reasonable rate of return on the investment. And the TDR system, in this case, what entered into that calculus when the court said we have to consider that air rights could be transferable to other parcels, so that this was part of the way in which there was a reasonable rate of return. Yeah.
I think I missed something big, so let me, if I could just try to speak up a question. A landmark is a type of taking, is that correct? Potentially, or a potential criteria for taking. And I guess I'm asking even more holistically, is it taking considered okay according to the Constitution if it meets that high threshold that you had alluded to? And I'm sorry if I'm not using the right nomenclature, but I'm asking, like, what is the source of that allows for a taking to occur?
Right.
Is it in the Constitution, or is it by delegated to states? I'm sorry, I lost where it came from.
Okay.
I'm sure it's like really important.
Okay, let me answer that in a couple of ways.
Okay.
We're talking about, at this moment, the U.S. constitutional protections against takings.
Okay.
States also have their own takings constitutional protections.
Okay.
And often the courts approach those the same way they approach the federal takings law. But right now we're just talking about federal takings law as applied to the states through the 14th Amendment. Okay.
Okay.
And what this says, what we're talking about is when is there a taking? Because if there is a taking, just compensation is due under the Constitution. If there is a taking, just compensation is due. Under the Constitution.
But is it under an amendment?
Yes, it's under the 5th Amendment and 14th Amendment. Remember, 5th and 14th. Okay. So in this case, in the Penn Central case, the court decided this was not a taking, so no compensation was due. Okay, and they used the 3-part test that is in the prior slide to analyze when there's a taking and when there isn't, and applied it to this case.
Okay.
And so that's what the courts will do. They will look at the particular facts of the case and apply that 3-part case, 3-part test to a regulatory taking. One caveat: if it's a per se taking, if there's a physical invasion, not an inverse condemnation, but a condemnation or physical invasion, the compensation is due.
But in that Penn Grand Central case, was the Preservation Society the Preservation Commission a state commission?
Yeah, no, the landmark law was adopted by New York City.
So city.
Yes.
But the 14th can apply to states and cities?
Yes.
Oh, okay.
Yes.
Right.
For the purposes of the 14th Amendment, local governments are like the state. Because
Oh,
local
s-
governments are creatures of the state.
State, county, local, it's all
Yeah.
covered.
It's all covered. Right, okay, basic questions, I know, otherwise,
Yeah.
it's a lot of new stuff to think about. And so here's an example, this case, Loretto versus Teleprompter, CATV, involved a cable company. And this is an example of where the court considers a physical taking to be a per se taking and compensation is due. In this instance, New York State law required landlords to enable cable TV wiring on buildings without payment to the building owners. And the landlord said, wait a minute, why should we make our buildings available to the cable TV folks? This is a taking of our property and we're due compensation. And the court said, when it eventually got up to the Supreme Court, yes, we believe this is a physical invasion. You physically have to have the cable on your building. It's not just a regulation about how you use the building. It's you have to give up your property, no matter how small, to put the cable on it. And that we consider a per se taking, and that's due compensation. So they send it back to the lower courts to determine how much compensation the landlords were entitled to. And in the end, the courts decided, well, very minimal, because in fact, once the cable equipment was there, it actually increased the property values. The landlords won, conceptually, but the damages were $1.
I remember.
Okay. Another twist on the takings law is the issue of temporary takings. When a government regulation regulates, but only temporarily, only for a certain time frame. And the case that embodies this principle is a case out of Los Angeles County, First English Evangelical Lutheran Church versus Los Angeles County. The facts in this case involved a church that owned and operated a camp for disabled kids, basically in a valley outside of Los Angeles, in Los Angeles County. And that church camp was destroyed by a flood. And as a result, the county decided it needed to figure out better flood regulations, and it adopted a moratorium prohibiting reconstruction of that camp and buildings within floodplains for a certain time frame while the county figured out better flood regulations. And the church said, well, we're unable to use our property. The county should compensate us for our loss during that time period, the moratorium time period, where we can't use our property. The state courts in this case said that if there was a taking here, you could that the regulation had to be invalidated, but they wouldn't provide a remedy of monetary damages. So it went up to the Supreme Court. The Supreme Court said where there is a temporary taking, just like other takings, monetary damages can be due. It isn't, unlike what the state was saying, it's not just invalidation of the ordinance. In fact, it's a monetary remedy. The court here did not actually decide if it was a taking. It was just a question, conceptual question of what the remedy would be if there was a taking. So it sent it back to the state courts to decide whether there actually was a taking, a regulatory taking. And in that case, on remand, the state courts decided that no, using that three-part test, there was not a regulatory taking here. That, one of the tests is, how reasonable is the regulation? And the court said, obviously, there's a public benefit in keeping handicapped children out of harm's way while there's a better regulation created, and that outweighed the church's economic loss.
Yes.
How many, as a natural history, more on the topic of moratorias, how does the APA normally, that's a very legal.
Well, there's going to be a case that's going to come up in a minute.
Moratorium.
Yeah, we're gonna talk more about moratoria later on, but this is a good moratorium case in terms of showing you that moratorium are not necessarily takings, and they're not, but if they are, that monetary damages can be a remedy.
I followed the legal steps that you went through. I am an engineer, but I don't want to get off topic, but I just don't understand why it was an interim moratorium. Did they do some remediation there? Like, it doesn't make
They did.
technical sense.
Oh, well, it makes a lot of
I
sense
just don't know
because
what it is, yeah.
the reason for the moratorium not allowing rebuilding in the floodplain while the state created flood regulations was to give the state time, like all moratoriums, to actually do the regulations
Oh, like
and
the
apply
50
them.
or the 100-year and just.
Right, and-
It was that early?
And the state said, we're not going to allow the church to rebuild while we're doing those regulations. By the time we get our regulations done,
Right.
it'll be too late if we determine that the regulations say they shouldn't rebuild there. So we're going to stop the rebuilding until we've adopted our regulations.
It actually was a county.
Did I say state? I meant
County.
it's Los Angeles County.
It could have gone any direction. In principle, it could have gone, you have to wait for the regulations. You can't do anything until the regulations are issued,
Correct.
and then.
In this
big
instance.
Question mark what that regulation would be.
Right.
Yes,
Um,
yeah. And we'll talk about moratorium and when they're considered reasonable in later
Okay,
cases.
okay, makes
One
sense.
of the issues with floodplain regulations is that there's some technical evaluations that need to be done. And usually there are, I'm standing right in front of the microphone, Henry. And part of it is you want to avoid any kind of development in certain pieces of the floodplain, like the flowway. There are also issues of compensating storage in other parts of the floodplain that have to be taken into account.
Mhm.
There's issues on minimum elevations, things like that. So that's the whole point of having a moratorium while you're developing those regulations.
Yeah. I'm just, because of my age, I'm just more used to the floodplains being already delineated before this,
That was 1987.
Spoken like a true ex-employee of the Water Management District. Okay, let's go on the next slide. All right, another case that comes up that's important is, and it's very applicable in Florida for those of us here in Florida and those listening, is the Lucas case, Lucas versus South Carolina Coastal Council. And this was a case where South Carolina experienced a hurricane. The state denied building permits on 2 oceanfront lots that had been, vulnerable to the hurricane. The state had established a coastal regulation that created a setback line. We're familiar with that in Florida. So the buildings were supposed to be constructed landward of the setback line, but in this case, the lots were seaward of the setback line, so the regulation would not allow buildings in that area. And the owner, Mr. Lucas, challenged that regulation as denial of his building permits and said, this is a regulatory taking. If the state wants to say I can't build there, then the state should purchase this property, pay me compensation for the property. And in fact, the Supreme Court agreed, calling this a per se categorical taking. In other words, a regulation that denied all use of the property, all economic use of the property, like a physical taking, should be compensable. And in this case, because there was no use of the property left, the court said there wasn't even any need to examine the underlying public purpose or justification of the regulation. The state went too far pursuant to that very early case we talked about, the Pennsylvania coal case. So this is probably the main reason that you see coastal regulations allowing construction within areas that you think probably should not be constructed upon, because if you can't construct anything, then you're considered to have suffered a per se taking. So the story here is that when this case went back down to the lower courts, the parties settled, and the state actually ended up buying the lots, and then the states sold the lots. And I don't know, I'm sure we can find out, and I should for the next time, whether or not there's actually anything built on those lots now.
I think there is. There's, they were in an area where there were a line of other units that were there. They moved the setback line.
Yeah.
And those lots were the vacant ones.
It gave them an exception and allowed them to build. Okay.
So here's our other moratorium case.
So having gone through that per se taking analysis where you can't do anything on your property, the next question presented to the court was, okay, suppose you have a moratorium. Now, would you say, because you can't do anything on your property during that moratorium period, that a temporary moratorium is a per se taking? Can we expand the Lucas decision to undo what was done in the Los Angeles County case? And this is the interesting thing about takings cases. There are always a lot of different permutations in a different court and different fact circumstances. And whereas plaintiffs here thought they had a pretty good case based on Lucas, it turns out they didn't. And this Tahoe case involves a regional planning agency, a multi-state regional planning agency.
This is the state line right here.
Formed to protect Lake Tahoe, which anyone has ever been to knows that it's an outstanding, incredibly beautiful and pure lake. And for that reason has been a place where people want to build a lot of residences. And it became pretty obvious that lots of building there was going to adversely impact the lake unless there was some good regulation. So the planning agency enacted a moratorium, in fact, enacted one and then extended the moratorium so that building permits could not be issued during the moratorium while they created their new rules. And it ended up that the moratorium took about 32 months, during which owners could not pull the building permits.
Now, they had it on and off and on again. It was...
Right, but the court was presented with this 32 months. Is that, unreasonable? And the court said, well, in every taking case, we have to look at all the facts, and it's very case specific. So they looked at these facts and they applied the criteria of Penn Station, Pennsylvania Coal. I don't think that's right. It's the Penn Station case where you look at the parcel as the whole, look at all the rights available to the landowner and apply the three criteria. They said, in this case, if you look at the parcel of the whole, the time period is part of that whole system, that whole bundle of rights. So you might not be able to build during this limited moratorium time period, but you have rights to build after that. So we're going to look at your rights more generally as a whole. And in this case, we're not going to consider a moratorium a per se taking. And then, the case also has language about how beautiful the area is and how important the regulation, the public purposes for the regulation was. So, on to the next slide. One of the questions that's come up.
I had a quick question about the last one, just real quick. Can you hear me?
Go ahead. Yes.
So was there any compensation, or was that not required for that moratorium?
Because there was not a taking, there was no compensation due.
Okay.
Compensation is only due when the court finds a taking. And then they determine how much compensation is due.
Okay.
If there's no taking, then there's no compensation.
Okay, thank you.
Okay. Then another issue that's come up in takings cases is related to that one test of the three-part test about the owner's reasonable investment-backed expectations. And the question here is, if you buy property and you know that property is restricted and severely restricted, can you then later claim that the state has taken your property? And this case came out of Rhode Island and involved a wetlands area where the state regulated wetlands, but went through a rule change to make wetlands restrictions, more restrictive. When Mr. Palazzo acquired the property, the wetlands, it was after the rule changed. He was denied a permit under the old rule and sued for inverse condemnation, saying that, well, I knew that you were changing your rules, but you denied me this permit and it's unreasonable, it's a taking, you should pay me compensation. The state courts threw him out and said, you have no standing to sue because you acquired after the rule change, so you can't claim, you don't have a claim now. But the Supreme Court took up the case anyway and said, well, yes, even though you knew about the change of a regulation when you bought your property, that does not automatically mean that you can't bring a takings claim. There's, the way they said it, that there's no statute of limitations on the exercise of constitutional rights. If the regulation is unreasonable and denies a reasonable use of the land, then it shouldn't matter that the property owner took after the regulation was adopted or before. If it's unreasonable otherwise, then it's unreasonable for anybody. Prior knowledge does not preclude a taking. Again, on remand, the owner had won at the Supreme Court conceptually, on this principle, but when it got to the details of the case, the court decided that there had been no unreasonable loss of value as a result of the wetlands regulation. All right. Did you have a question?
No,
Okay.
thanks.
All right. Let's take another a look at takings law and police power aesthetic purposes. One of the tests of takings, again, relates to the reasonableness of the government regulation. And there have been challenges to regulations that were considered to have a purpose only for aesthetics and nothing more. And one of the first cases that challenged actually a condemnation, an urban renewal law, where the Washington, D.C. urban renewal law allowed for condemnation of property based on blight. The court decided that an aesthetic and a redevelopment purpose was a legitimate purpose for the use of the state's condemnation power. So this was a great confirmation of the use of police power for aesthetic purposes. Fast forward, this was a 1954 case, and fast forward to 2005, where the city of New London, Connecticut, had a urban renewal program where they justified the condemnation of an entire neighborhood solely on economic development purposes, where there was no blight or slum conditions that had been proven. The Supreme Court was asked to determine whether that was a taking, a regulatory taking. In other words, did an economic development purpose in itself without blight or slum conditions justify the regulation? And the court decided that there was sufficient public purpose under the Fifth Amendment to consider that this was not a taking. And they hearkened back to the Berman v. Parker case, and in this case deferred to the legislative judgment. So this may be a surprise to some people that the Supreme Court said that was fine, because the reaction to that in the states was to politically go back. Many legislatures went back and looked at their community redevelopment legislation and made sure that economic development in and of itself was not sufficient from a statutory standpoint. So a lot of those statutes got changed.
So I'm just asking, at the end in New London, did everybody just lost their homes and they had to leave? Like, what was the actual?
What happened was that their homes were condemned. They were paid just compensation, but
Even though it wasn't defined as a taking.
It was
it was a legitimate taking,
I'm sorry.
and they were given just compensation.
Why does it say and not a taking under SCOTUS paragraph there? That's why I said that. That's why I'm getting confused.
Because there was a legitimate public purpose. So
But
the
you just said it wasn't
condemnation.
taking and I'm reading not a taking.
You're right. You're right. What?
I'm all sorry.
Just go back to the principle that economic development and aesthetic purposes are sufficient public purposes to justify condemnation, that the government can take for those public purposes. But if they take, then they have to give just compensation. That is a confusing slide. We will change
So
that.
it was a taking.
Yes, it was a
Okay.
condemnation. It was the old-fashioned condemnation.
Sorry about that, I just got confused.
And it was justified as a legitimate exercise of the police power.
But didn't they still have to provide compensation?
Right.
Yeah,
Yeah.
that's under the taking, yeah.
How would you want to say that, to address that?
You're the first person that ever pointed that out, so we will
Or
correct
do you want
that.
to say that?
It is a taking, it's not a taking.
What slide is that? And we have
It was just an error.
a number.
I can't tell what our.
All right, it's the Berman slide.
This kilo is 24.
Okay.
24.
Good.
Yeah, I mean, realize that every state in the union passed some restrictions on community redevelopment. And what it did here in Florida was that Riviera Beach was about ready to go with their big redevelopment, and do a lot of eminent domain. And what the state legislature did in Florida was they said, you cannot use eminent domain for community redevelopment type agency activities. To take property, you have to do it from willing sellers.
In all actuality, the state completely stripped community redevelopment agencies of all powers of eminent domain. And then they also,
Yeah.
all CRAs in the state were stripped,
So, and that's what happened to Riviera Beach.
all CRAs.
Around the country, it happened in different degrees. But there was basically all 50 states have passed some reaction to Kilo. It's a gradient of what they did. Florida's on one end, a little bit more, which basically said, you can't use eminent domain for this type of activity anymore. Okay, go ahead.
But isn't that against the federal law?
No,
No. The takings law that we're talking about is whether the Constitution protects against takings. The government, the states can further restrict police powers. So,
Okay, got it. So the
So-
federal is like, but it gives like sort of the option of doing the taking, and then if there is a taking, you're due just compensation. I'm sorry if I'm
but
saying.
Florida outlawed the ability to take people's homes, for instance, or to take private property for redevelopment purposes. Nancy can say it better than I can, but
But I'm saying, and I'm sorry if I'm just narrowing it too much, but it almost seems like functionally that, like the federal law gives the states the option of doing the taking. But if they don't, I'm sorry, if they do, if it's in their statutes that they can do a taking, then they must compensate.
no, let me put it one way.
Okay.
The state law can be more protective than the Constitution. The Supreme Court can decide as a constitutional matter that this isn't an issue, but the state can say, but we want to further restrict, regulation, and we're going to do it by statute. And that's exactly what they did for the community redevelopment statute in the
Got it.
states.
They're further.
So even though it's not a constitutional problem, it could be a violation of the state statute because the state statute is more restrictive.
now, if they needed it for a road, if the same city wanted it to put in a road or a new public building, that may be okay, because it's not restricted. But in Florida, you can't do it for redevelopment purposes for like the reasons that
I
normally can.
I'm sorry, I'm just coming totally from the outside of this, but the federal rules that allow for taking in the first place, are they geared towards is the client, if you will, the state, or is it the citizen? Or
It's a person's rights under the Constitution.
to be compensated for the
Yes.
state taking from him? If the state.
If it's a federal constitutional violation, then if a state has regulated in violation of the Constitution, then the federal courts will say you have to compensate.
Maybe
Right.
part,
Then, now the state statutes are sort of a different level of regulation. So you might be allowed to do something that's constitutional, but the state can say, we want to be even more restrictive. So, and the Constitution, it's not a violation to have a condemnation for economic development purposes. But under the statute, it's a statutory violation because the legislature has decided, as a matter of state statutory law, that's a violation.
realize that Kilo was saying, even if you say that you can take my house and you're going to compensate for me, that's illegal because there's no slum and blight
Yeah.
present, okay?
Mhm.
And the court said, no, they can do it. For reasons or enough,
Under the Constitution, they can do it.
under the Constitution, but the state can further restrict it.
And I apologize, which amendments did the case law originally emanate
The
from?
5th and the 14th
Was the
are the
fifth?
takings.
And I'll give you
Amendments.
copies of the Constitution with the 1st, the 5th, the 10th, and the 14th underlined, the appropriate sections that come up in black. We have a little over, just about an hour.
Okay, let's keep going. Another area that's been of particular interest on the AICP exam is the area of exactions. And there are several important cases in exactions law. The first being Nolan versus California Coastal Commission. Now, exactions are when a permit is conditioned on the permit holder giving something to the agency that permits, dedication of land, fees. In this case, it was public access to the general public. This case comes out of California that regulates coastal construction through the California Coastal Commission. And one of the policies of the California Coastal Commission is to help ensure public access to California coasts. In this case, the Nolan family had an oceanfront bungalow that they wanted to tear down and erect a larger house. State agency said, fine, we'll issue you a permit, but as a condition to the permit, you have to give back to us an easement for public access along the beach, what's called lateral public access,
There's a park at either end. It was in between.
Right, so we want you to give the public permission to walk along the beach from one park across your property to the park down the beach. And Mr. Nolan said, oh, well, if you're going to do that, and then that's a regulation and you need to compensate me for the, public's use of my beach. You can't just put that as a condition to my permit. And the Supreme Court agreed. They said this kind of exaction has to show what they called an essential nexus, which is essentially a close tie of the condition to a legitimate state interest. And in this case, the court said California had not shown that its condition was tied to a legitimate state interest. In fact, California's justification during the course of the case proceedings was they required these public access easements so that people traveling along the road behind the bungalows could view the beach. And the court said, that doesn't make any sense. How does, providing a lateral access help the view from the road?
You couldn't see,
So-
you can see here, you can't even look up and see the
So
cars on the roadway.
So they said, no, this is, in fact, said this was a violation of the Fifth Amendment. And they also said, which was quite a change in the law, was that, remember when I said when there's a legislative action on the part of the regulator, the state, the courts usually give the burden of proof to the challenger. And, the challenger has to come in and explain why and, make its case. In this case, the Supreme Court said, it's up to the agency, the permit agency here, to justify its rational nexus. And in this case said that they didn't do that. So this case, the Nolan case, is considered one of two cases that established the dual rational nexus test. So this is the first test, the essential nexus, and this next case we're going to talk about is Dolan versus the City of Tigard, a second exactions case where the court established the second test. So in this case, coming out of Oregon, a commercial establishment wanted to expand its building, and the court said, you can do that, we'll issue you a permit to do that, but because of your location, we're going to require certain conditions to the permit. And one condition was the landowner had to give an easement for a bike path that had been planned and that traversed the property, and also for a storm drainage area that was part of the property, and had to give an easement to allow those path and storm drainage improvements. And the result of this regulation in this circumstance was about 20% of the property was not to be built on because it was going to be subject to the easements. So the property owner said, well, this is a takings. If you're going to require me as a condition of the permits to do this, then you should pay me just compensation. And the court said, yes, that's true. And in this exactions case, the court found that the conditions had an essential nexus to the legitimate public purpose. Providing an easement helped for creating the bike path and for protecting the drainage area. But it said, we're going to require something else. The second test in these exactions cases is that the exaction has to be roughly proportionate to the impacts. So, and that language you might recognize as being part of Florida impact fee law. In other words, though it might be a legitimate purpose and an essential nexus was shown in that the first instance, there was no evidence in the record here that the amount of property that was being required as a condition was proportionate to the impact of the expansion of that property. So in this case, the court found that this was unreasonable and a takings.
So that makes the dual nexus test two parts. You have to have a connection to the impact, essential nexus, and you have to be roughly proportional. The exaction has to be roughly proportional to the impact created. So you can't require a single-family house to build 5 miles of 4-lane divided highway for transportation purposes.
But you can require it to contribute to a fund at some later future
Maybe,
date.
right, maybe an
That
impact
capacity
fee or
to
some
avoid
kind of fund proportional to their impact.
But it has to be proportional. It has to meet, even if it's giving money, and that's what this next case is about. You have to meet the dual nexus test. And so the recent case that really sort of hammers this home is the case out of Florida, the Coons versus St. Johns River water management case. These are interesting facts. And that raises the question about just how well it fits into the takings genre. But it's important for a number of principles. In this case, there was a property owner that wanted to build on property that had significant wetlands and came to the Water Management District for a Water Management District permit and talked to the staff about it and went through the process of, applying and getting comments back and meeting with the staff and negotiating what the conditions might be. And the staff said, well, there's a couple ways that you can mitigate, your wetlands impacts, and here are 3 different ways to do it. You can pay into a fund, you can give us an easement, you can make some improvements off-site, within the same basin. And all of that, will get you a recommendation from the staff for a permit. And Kuhn said, no, I don't want to do any of those things. I'm just, I just want to go to the district and take my chances. And the district said, why don't you want to do any of those things? They denied the permit, and the property owner, Mr. Kuntz, came to the court and said, this is a taking. It was an attempted extortion on the part of the staff, and I should get compensation. So this case eventually got up to the Supreme Court. It was actually Mr. Kuntz Jr. who was around when the court decided. Mr. Kuntz was elderly and didn't survive, but the Supreme Court decided that the dual nexus test applied in this case, even when the permit was denied. And so we weren't focused on the conditions of a permit, because there were no conditions of a permit. There was no permit. It was the action of the staff in trying to mitigate and suggest these conditions that was unconstitutional. And this is what makes it a crazy case, because the court didn't actually rely on takings law here, although it's considered sort of part of that set of takings cases. They said this was an unconstitutional conditions case, that government may not require an individual to give up a constitutional right, in other words, it's just compensation for taking, in order to obtain a government benefit. And the court also said that the dual nexus test applies to money, not just land dedications. But they also, in a very squirrely way, said, even if there was a unconstitutional condition violation here, we're not saying that there's a damage remedy. In takings, there's a damage remedy. So they said only if the state law requires it. So this is a case I really kind of doubt that you would see on a test, because it is a bit squirrely, but it does, for at least one point, make a difference to the takings cases, and that is for exactions, money conditions can be considered a violation.
A lot of time trying to deal with this particular case. But we expect it may show up on the exam, but we have not seen it definitely on the exam yet.
But Florida people should know this case, because it's one of those, crazy Florida cases. But it's also important for that issue regarding exactions applying to money conditions.
Nor has it shown up on any of the practice questions that we.
So we'll go on, because we spent enough time on this. Okay, so we're done with the takings cases for the time being, and let's go on to due process. Again, this is the Constitution, federal Constitution protects persons from deprivation of life, liberty, or property without due process of law. And that's applicable to state action through the 14th Amendment. And there are 2 types of due process cases. Persons are entitled to procedural due process. In other words, persons are entitled to a fair procedure when their rights are involved. The court will determine in this instance whether, for procedural due process, there's been reasonable notice and an opportunity to be heard by an impartial judge, tribunal. That's the basics of procedural due process under the federal Constitution. And that process cannot be arbitrary or capricious or confiscatory. The other kind of due process is substantive due process, and this is where the court looks at the substance of the law, the content of the law, not how it's being applied through the notice and hearing process, but what does the law actually say? And in this case, in substantive due process, the plaintiff will say that the content of the law is arbitrary and capricious. It has no reasonable basis. And a lot of zoning cases, a lot of regulatory cases are, in the past anyway, has been challenged on their reasonableness. It's just, if it's not a taking, but it goes too far, it's unfair, it'll be brought under the due process clause. And the courts give a low level of scrutiny to due process claims, federal courts in particular. As long as there is a rational basis for regulation, the courts will uphold the regulation, and they give the government the benefit of the doubt. Again, it's up to the plaintiff, the challenger, to prove that there's no rational basis to the regulation in order to find a violation. For certain kinds of cases, the courts will do more than a low level of scrutiny. They will look a little bit more closely at the regulation, and they won't ask whether there's a rational basis, but rather, does the regulation substantially advance a legitimate state interest? And in certain cases, the court will even look at a law in terms of strict scrutiny. And strict scrutiny usually involves First Amendment rights or very limited set of particular kinds of rights, abortion, right to die, things that are very personal kinds of liberty issues. In a due process case, there's no need to prove a loss of value. The remedy is not money damages, but nullification of the law. So let's look at a couple of kinds of due process cases that arise in the zoning context. And the first case to look at here is City of Eastlake versus Four City Enterprises. In this case, in the city charter required zoning changes to be subject to popular vote and to be passed by popular vote by 55%. And the city had rezoned property from industrial and to from industrial to multifamily to build, so the developer could build a high rise, but it went to referendum and the voters did not approve that by 55%. They overturned the city's approval. The developer went to court and said, this referendum requirement is unfair. It's a violation of due process, arbitrary and capricious. It needs to be overturned on a constitutional basis. And when it got to the Supreme Court upheld the referendum power here and said, this is a legislative act under our review of legislative acts. We're just going to see whether it has a rational basis. The state constitution here specifically reserves the right of referendum to the people as a legislative act, and so plaintiff went home without a win. Now, one question is whether in some states where zoning is not considered legislative, but a quasi-judicial act, the court would look at the referendum power the same way, the referendum for zoning in the same way. We don't know. All right, so will the court examine motives for legislative enactment or executive decisions? Well, not generally, especially legislative decisions. Although legislatives and executives need to not discriminate and treat like people alike, generally, if it's a legislative action, you only need to have a rational basis for your legislative action, again, the lowest level of scrutiny. However, and zoning, let me just back up. Zoning, by its nature, discriminates, right? Some properties are zoned for higher density intensity than other properties. But the courts say for zoning purposes, that's a legislative action that we're not going to look very closely at as long as there's a rational basis. And zoning's been accepted as being a legitimate exercise of state police power to protect the community and for other reasons, for aesthetic reasons and so forth, so that it won't be overturned. On the other hand, there are some exceptions where there is a regulation that affects fundamental rights or a protected class being distinctions based on race, religion, or national origin. Then the court, in reviewing a regulation that discriminates and affects these fundamental rights or protected class, will apply the highest level of scrutiny. And they'll say, if you're discriminating between racial minorities and the majority, then the government has to show a compelling state interest for its regulation. And whenever you see compelling state interest identified by the court, you know that the government's going to lose, because it's very rare that the court will find a compelling state interest to discriminate. There's also a level of intermediate scrutiny that the court will sometimes apply to certain other classes or groups that are not considered protected classes, but classes that are sort of semi-protected. And those are, for example, classes that are persons that are handicapped or sexual minorities. So there's that intermediate level of scrutiny there. Rarely applies in zoning, but it's important to know the distinctions.
Yeah, of course.
Would a higher level of scrutiny apply to a protected class as opposed to a semi-protected class?
Okay.
I would think it would be the way around.
The higher scrutiny means that it's going to be more difficult for the local government or the state to prove their case. The court's going to look at it much harsher and much more detailed. I'm a layman saying that, not an attorney. I don't know if you want to say it a different way.
Oh, so the plaintiff would be the citizen being discriminated against in that
Right.
case?
Right.
Oh, okay.
Right.
Okay. I wasn't clear on that. Okay.
Right.
Now it's clear.
But the federal government allows discrimination for housing for older persons. For housing.
Well, we'll get into some of these
Right.
cases. So, for example, Village of Arlington Heights was a case where a church wanted to build subsidized multifamily low-income housing in a suburb of Chicago, which was largely white, did not want a low-income housing project, and refused to rezone the property to allow the low-income housing project. This is not an unusual example, right, throughout the country. The church sued and said this refusal to rezone has a negative impact on a protected class, that is, racial minorities. Then the court should look with strict scrutiny on this and strike down the government action. And the court said, well, in order to prove a negative racial impact, this discrimination, you can't just look at the impacts. You have to have proof of discriminatory intent. The government has to clearly be doing this, intending to discriminate. So, you know, city council members who are saying, we do not want those kind of people here, might show some sort of intent. But otherwise, it's going to be very difficult to overturn a rezoning based on impacts on racial minorities for constitutional purposes. But, as you pointed out, fair housing laws can protect those racial minorities without proof of impact. So if you're going to challenge this kind of rezoning, you can challenge it without having to prove discriminatory intent, and only prove discriminatory impact through the fair housing law. Another case bringing in this question of whether there were protected persons that deserved more scrutiny by the court was Village of Belterre versus Boras, which involved a town on Long Island, which was adjacent to the State University of New York, and it had a lot of students around, and the town, the village, did not want to allow a lot of student housing, and so to do that, they created a zoning ordinance that allowed for single-family zoning, but they defined zoning to exclude student housing, basically by saying that a family does not include more than 2 unrelated persons living together. And that was challenged and eventually went to the Supreme Court, and the Supreme Court refused to look at this with more scrutiny than the typical fairly debatable low level, is there a rational basis for this? And so the village's ordinance was upheld. How about the Equal Protection Clause, which protects against discrimination when there is a minority of disabled persons, or in the case of the city of Claiborne, 1985, these persons were described as feeble-minded and retarded, and the city denied a special permit for a group home for these disabled persons, and because of that denial, the group home challenged the regulation and asked the court to find that, in their words, retardation was a quasi-suspect category that required more scrutiny, heightened scrutiny, under the Equal Protection Clause. The court refused to give that kind of heightened scrutiny to disabled persons. They distinguish this group of disabled persons from the heightened scrutiny that they give to race, religion, national origin. So they refused to give that heightened scrutiny, but they nevertheless overturned the regulation on the rational basis ground, saying there wasn't a rational basis. So sometimes you lose on the principle, but then you win on the on what you weren't expecting to win on. Again, federal statutes can protect what the Constitution does not protect. So in this instance, the Americans with Disabilities Act, protects what the Constitution might not protect. And the federal statute, which is known as Section 1983, is a statute that protects federal rights and is used quite often when challenging regulations because, remember, for example, in a due process challenge, your remedy is not to get compensation if you're successful, but it's to overturn the regulation. Section 1983 allows persons whose due process rights or equal protection rights were violated to get compensation. So it's an extra protection for those rights that otherwise the Constitution just says the regulation's unreasonable, you have to invalidate the regulation. Okay, let's go on. Again, the Fair Housing Act is another one of those statutes that protects more than the Constitution protects. And one instance in which it was brought into play was the City of Edmonds versus Oxford House case, in which the City of Edmonds, which is outside of Seattle, regulated in its zoning basically to disallow for group homes because it defined family as no more than 5 unrelated persons. The Oxford House is a really well-established nonprofit that runs group homes for recovering alcoholics, and they wanted to locate an Oxford House there, but they were basically told that their zoning didn't allow it, and they were cited for a code violation. Oxford House here claimed that the Fair Housing Act prohibited discrimination based on handicap, and the Supreme Court found that, yes, this ordinance should be and could be reviewed under the Fair Housing Act. But even under that review, the court found that it was reasonable under the act because the intent was to preserve the family character of a neighborhood. So Oxford House lost in this instance. So we're gonna move on to. Are you tired yet? You have some more cases, but you'll have a chance. Let me pause here and say, this is where the resource materials are so good. You can go back, you can get summaries of all of these cases. Read the cases. Some of them are easy reads.
The law division of APA has put out a summary of most of these cases, and I will have that on the FTP site for you, as well as this presentation.
Most of them are in the CPC guide too.
Yeah, so
The Chapters President Guide has some of them, but the APA the division put together specifically to sort of address the exam, many of the cases here that you need to know.
And we've gone into some detail on these cases because the facts are important. I think they also may help, they're all stories, you know, and they help you, if you know the facts and the stories, they help you get to the principles that are being decided. And
Sometimes on the exam, they will not ask about a specific case, but they'll ask about the principles. They'll have a scenario question that forces you to know what dual nexus is because it asks you, how do you do this? And it's knowing dual nexus is what your test is that you have to use. So it's a lot of scenario questions utilize some of this information.
yeah, so it's important to know the stories behind the cases and, you know, identify the case names with the principles. Let's see, we're going to pivot now to some state law cases. We're now out of the federal constitution and statutes for a while. And let's look at some cases from the states that are likely to come up on the exam. And one important series of cases, the Mount Laurel cases, come out of the state of New Jersey, which, like many states in the 60s, were experiencing loss of basically more wealthy or middle class white populations to the suburbs, known as white flight, and leaving the cities in bad economic shape. That's turning around now, but back in the 60s and 70s, this was a very important population trend. And as a result, many of the suburbs of these cities zoned to discourage integration and, you know, the movement of the racial minorities and economic minorities to the suburbs. And in this case, the first Mount Laurel case, Mount Laurel had a PUD zoning that the African American community wanted, it claimed to be discriminatory, that the AME church had asked for permission to rezone PUD to allow for townhouses or replacement housing, and the township denied the rezoning. The New Jersey Supreme Court took this case and interpreted the state constitution to require all municipalities in New Jersey to provide their fair share of the regional need for affordable housing. The Supreme Court did not look, the US Supreme Court did not look at this case. So this is a case, a state law case from the New Jersey Supreme Court. This created a huge series of cases to follow. The New Jersey towns were very reluctant to provide their fair share of regional housing. And when the next case came up to the Supreme Court said, we meant it, and you have to provide a fair share, and in fact, the state needs to do it as a whole, not just this particular municipality. And so the state legislature got on the ball and adopted legislation to apply statewide to create this fair share program. And they created the standards so that the New Jersey Supreme Court would not create the standards for the state.
We haven't covered history yet, but another thing to note with these two cases is that Paul Davidoff, who is the father of advocacy planning, was involved in both of these through, I think it's called something like the Suburban Land Institute. And we'll talk about that more when we do history, anyway. That connection
Next
comes
slide.
up, that's why I mentioned it.
Okay. You can go to the next slide.
Yeah.
Okay.
When I flip the other window open, it won't let me do that until I.
Okay,
click.
sorry.
So,
There's actually another Mount Laurel case too. I mean, the cases have been generated over more than a decade trying to figure out how to make the fair share requirement work, because it is, according to the New Jersey Supreme Court, a constitutional requirement. So moving on back to the federal law and the First Amendment, where we look at some free speech cases.
and we have about 25 minutes.
Okay. And how many? I think we
more
might need
cases
to
we
go
have to
more.
go through?
Yeah, no, we got some more.
Just a second, I'll tell you. There's 53 and we're on 36.
Okay. The last part is a lot easier. That's not
Yes,
as much.
It goes faster.
Not as much case. Okay. So the First Amendment protects free speech. And the court has held that sexual expression is a form of free speech. So there are a number of cases involving zoning regulations that try to regulate the location of adult-oriented uses. And one of the important ones to know is Young versus American mini theaters, where Detroit adopted a zoning system that dispersed adult entertainment, required, spacing between adult uses
Is that where the 1,000-foot rule comes in?
Sorry?
1,000-foot rule?
Yeah, something like that.
separation.
Yeah,
That's
that's a
the
typical
case here.
kind of
Oh, okay.
spacing requirement.
Oh, sorry.
And
That's
this
right.
This was in order to prevent concentration and a skid row kind of thing.
Or by schools, yeah.
Yeah.
Or churches.
And the question was, what kind of scrutiny will the Supreme Court give to this zoning regulation that implicates free speech? Will they do strict scrutiny and require a compelling state interest so that zoning cannot really regulate this? Well, Supreme Court decided that this kind of speech is low-level speech, even though it is protected speech. And so they were not going to strictly scrutinize this zoning regulation, and declared that the city's policy goals can be considered. It's okay to use zoning to control sexually explicit theaters and bookstores through this kind of separation requirement.
Does this fall under the commercial speech versus individual expression?
No, this is a specific kind of sexual expression speech. Yeah. The kind of twin to that case is City of Renton, where in 1986, the Seattle suburb required this separation from other kinds of uses. And the an adult theater owner sued to say this was a violation of free speech. And the Supreme Court again said, no, free speech, this kind of speech is low level, low value speech, and only intermediate scrutiny applied. They were not going to apply strict scrutiny. As if there's a substantial government interest, the restriction is really a restriction on time, place, and manner, and not content. And there is a reasonable alternative avenue of total communication. In other words, no total ban, then these kinds of regulations can be upheld. And so it's important for a number of reasons. You may have been involved in adult use regulations in Florida, where I've done several of these, where the number one thing you want to ensure is that there is at least one place where these uses can locate, because you cannot have a total ban on the uses. So as long as there is some place, it's
In
okay.
practice, can a municipality create a zone for such uses?
Absolutely,
Okay,
yes.
but thereby prohibiting it outside of that zone?
As long as it's within the city
Okay,
and that
that's-
zone, there's no total ban.
Red light district.
So free speech also applies to signs and billboards. And this is another important case to know, Metro Media versus City of San Diego, where the city banned off-premise outdoor advertising display signs. In other words, billboards, off-site billboards, and justified that as a means to improve the city's appearance, prevent dangerous distractions to motorists. They allowed on-site billboards that relate, to the property on which the billboard is sited, but off-site billboards were prohibited. The lower court ruled that this hindered First Amendment rights, subject it to strict scrutiny, and said the city can't do this. But the Supreme Court did not find this to be unconstitutional. So even though there was a distinction made allowing on-site billboards versus off-site billboards, the court said, let me back up here because I'm getting ahead of myself. In this case, because the regulation allowed on-site commercial advertising but did not allow non-commercial speech, the court said that this gave a greater degree of protection to commercial than non-commercial speech and went too far. The court is very concerned about protecting non-commercial speech. In other words, a property owner who wants to put up a sign saying, "End the war," whether it's a billboard or any other sign, is usually protected by the Supreme Court for those non-commercial speech rights.
Or political signs.
Or a political sign, vote, in favor of such and such.
Did the courts rule anything on the motorist distraction elements on it?
Yes, the courts will allow off-site billboard restrictions if you take care of this commercial versus non-commercial
Right.
issue. They will allow a prohibition against billboards, off-site
Based on
billboards,
the safety issue.
based on safety issue.
There must be regs or specifications on that. There must be.
Sign stuff gets really.
Sign's
we have a
very
whole session at
complicated.
the Conference typically, just dealing with signs sometimes. Because it's very complicated.
The Federal Highway, I forget the.
Unification Act.
They must have specs on these things.
Yes.
There must be.
The other thing
line of
is the
sight.
billboard agency has been really strong in terms of prohibiting certain types of restrictions
Right.
too. So there's. a
So
lot of
under
things.
the federal highway and state laws on that are based on the Federal Highway Act, you can prohibit off-site advertising, billboards in a certain area along highways. But you cannot require existing billboards to be taken down unless you provide just compensation. It's a complicated issue.
Speaking of which.
Oh, boy.
Okay, so here's another complication. Reed versus Town of Gilbert, which is a very recent case. This is a case that the Supreme Court reviewed a sign regulation that made distinctions between certain kinds of temporary signs. And for different kinds of temporary signs had different size sizes allowed and timeframes under which the signs could be posted, and numbers of signs that could be posted. And the court found that that was a violation of the First Amendment, that signs that are based on content have to be strictly scrutinized. There has to be can you go to the next? I think this is the test for the next. No, I guess not.
Maybe, is that what you added?
Maybe in other materials.
Okay.
That you can't, if signs are content-based, then the government has to provide a compelling state interest for that discrimination. And again, if you see compelling state interest and strict scrutiny in a First Amendment case, you know that the regulation is going to fail, because it's very rare that the court will accept a justification under that circumstance. So content-based signs are unconstitutional, violation of free speech.
Size, dimensions.
You can regulate time, manner, location, size. You can't regulate on the basis of content. And frankly, it's very hard to do sign regulations that don't somehow identify the content on the sign before it says how you can regulate the sign. So it's become very complicated to do sign regulations.
Do real estate signs have some sort of special?
Real estate signs are temporary signs. This was also included, in the case. Treated differently than political signs, treated differently than event signs. The court said all of that, you can't treat all those things differently. They're all content-based. They can only be regulated time, place, and manner regulations.
Great thing for a federal statute, just to say this is what the rules are.
This is a constitutional issue. Yeah, this is.
That was just two items that mean it's usually not. It's usually going to fill with strict scrutiny and you said strict
Compelling state interest.
Means that
the regulation's going to fail.
okay.
It's rare that a government can justify a regulation when that kind of scrutiny is involved.
We have 15 minutes.
Okay. The First Amendment also protects against discrimination based on religion and prohibition. That's you cannot prohibit free exercise of religion. And the First Amendment also says that the government cannot establish a religion. So there are a couple of cases involved in that religious exercise issue. Larkin versus Grendel's Den was a case in which a Massachusetts statute gave schools and churches power to veto the issuance of an alcohol permit for establishments within 500 feet. And an establishment was prevented from obtaining a liquor license, and the Supreme Court found that this zoning regulation violated the Establishment Clause by essentially delegating police power to schools and churches. So that's a good case. It'll probably end up. It sometimes ends up on the test. In terms of free exercise, I don't think the Jehovah's Witness case. There's an important case called Lemon versus Kurtzman. Look for this one, where the court says that a regulation that potentially interferes with the free exercise of religion will be subject to a three-part test. They'll look to whether the government regulation has a secular purpose. that it's neutral, it doesn't advance nor inhibit the exercise of religion, and there's no excessive government entanglement. And one example of where a regulation was struck down was a Florida case out of city of Hialeah, which banned ritual animal slaughter, which is really central to the Santeria religion, but made exceptions for kosher slaughter. And the Supreme Court found that this was not a neutral law of general applicability, but it had targeted a particular religion and therefore was a violation of the First Amendment.
Why didn't the prior adult example violate the Establishment Clause like it did in the alcohol case?
The Larkin case, it did violate the Establishment
Oh,
Law.
it did also?
Larkin did violate the Establishment.
Okay, I
Clause.
don't know about the name of the case. That was the adult business thing.
We've talked about two cases. So Lemon v. Kurtzman is just the principal. Okay.
I'm saying the prior case where there was the adult business, they said they had to let it exist somewhere in the township.
The city of Renton.
But why wasn't that case also?
Well, because here you're allowing the church to make the decision. The other situation, the city made the decision.
But even here, it says mass statute, it's the state making the decision, it's not, gives schools and, okay.
Yeah.
The effect seems exactly the same, so it just seems a little, okay.
I'm gonna move this on.
Okay.
You wanna?
It's important to know the RLUIPA statute, religious land use.
Things marked in red in this presentation particularly are really key because they come up all the time.
The Religious Land Use and Institutionalized Persons Act is an example of where the federal statute provides more protection than the Constitution, okay? Also known as RLUIPA, which was passed to protect against discrimination on the basis of religion, but it is directed to land use regulations and regulations for institutionalized persons. So this statute requires that land use regulations may not impose a substantial burden on religious assemblies and must use the least restrictive means and have a compelling government interest for any such restriction on religious assemblies. That's one thing, the substantial burden requirement or prohibition. And then secondly, the land use regulations cannot treat religious assemblies unequally from other types of assemblies. Okay, so a couple of cases that have come up in terms of substantial burden include this Club versus City of Chicago case where a conditional use permitting process was challenged as placing a substantial burden on a religious, on the location of churches. And basically, the court said that the conditional use process, even though it might be more expensive for applicants to go through, this was not a substantial burden on the exercise of religion, but was rather a neutral law of general applicability with a rational basis. Okay, so substantial burden is fairly hard to prove under RLUIPA. There are other cases where the assembly issue has been more successful for religious groups challenging under RLUIPA. For example, in Surfside, there was a case under which churches were not allowed to locate in a zoning area where other kinds of assemblies could locate. And this was found to be a violation of the RLUIPA.
I'm going to get us into the growth management.
Okay, and we're just gonna zip through this. Zoning, growth management cases, you see this in another, I think in another lecture, but this is just a typology of kinds of zoning regulations, early regulations regulating how much, where, and what can locate. In the 70s, some more emphasis on when uses can locate. That's when concurrency and adequate public facilities regulations came in. And the present time being additionally concerned with the quality of architecture and design. Okay, here's another case that falls into the category of early zoning regulations sort of based on nuisance law and upholding those zoning regulations. In this instance, it was a statute in Kansas during early prohibition times, basically, that declared liquor sales a public nuisance. And regulated against the location of a brewery. The court found that this regulation was okay. It was not a taking or due process violation because the state has police power to protect against public nuisances, in which case a brewery was considered a public nuisance. Village of Euclid, if you don't know this case, just don't even bother to take the test. This is the case that upheld the standard zoning kind of regulation that establishes different zoning districts for different uses. In this case, the village zoned property that was, as a result of the zoning, reduced by 75% in value, and the owner claimed a taking, a due process violation, an equal protection violation, and the court held that zoning here was a legislative enactment that was upheld under the principle that if it's a legislative enactment that is fairly debatable, that shows that it's not arbitrary and capricious, then it is not a due process violation. So this is the grandfather case that upheld the original zoning based on the Zoning Enabling Act.
And we'll get into many of these others. I just want to touch on these, and then I think we're going to have to end on these too.
Okay. Well, some of the growth management cases, there are 3 of them to know. One is the Ramapo case, which adopted what essentially is what we know as concurrency, a plan and zoning regulation based on the adequacy of public facilities, and permits were issued based on points for making those public facilities available, and the New York Court of Appeals upheld this system, and it was the first case that really upheld the power of a town to plan for its future, and a national model was really built, of concurrency was built on this case. Very important case. The Petaluma case was a case involving a growth management boundary and a phased permit system where building permits were limited to a certain number per year. And the construction industry sued in federal court, said that this was a violation of the constitutional right to travel without a legitimate government interest and a violation of due process. And the federal court upheld the city of Petaluma's system, birth management system here.
And Petaluma and Livermore, you need to know the difference because that comes up all the time in the exam.
Right. And okay, so Petaluma was a federal case. Livermore came out of the state of California, and this was an ordinance that had limited residential building permits until the adequate public facilities were provided. This was a challenge from the home builders, arguing that this interfered with non-resident right to migrate, in other words, right to travel. And the state court here upheld the system.
The infrastructure had to be in place before permits were pulled.
Correct.
And with that, we've run out of time.
So
So
good luck, everybody. Study hard, use these resource materials, they're great,
and there's more
And-
research material.
and you'll do well.
And with that, I've got to
Wait,
sign us off.
Wait 1 second.
Uh,
Anybody who is planning to order a CPC guide, you should go ahead and do it. There are copies available in the APA office in Tallahassee, and they can ship them out or hold them for you for the public policy workshop pickup.
All right, with that, I'm going to say, unfortunately, we have to go. Remember, next week, we do not have class. The following week, we will. I don't know what the topic will be, but it may be history. And that following week, we'll also start the Saturday classes
On the 15th.
on the 15th, okay? So with that, have a week off, and maybe I'll see if I can give you a practice exam. Something. All right, bye-bye.
Okay, Nancy.
Thanks, Nancy.
You're welcome.
Thank you, Nancy.
You're
Very
welcome.
much, appreciate it.